progress.
Share it widely.
Done.
So thank you, Ayushi. So glad to see such a good participation wide, like how Sachin mentioned, no, very diverse views. Um, some said they're excited to see what we have. I have to say that I only have a good question. I don't have answers. I have a exciting, tough question for all of us to work on and work together towards. It is not a tough problem. It's an interesting problem, and I think it is very much possible. Sachin mentioned how Shashwat and Pro Vakil have been trying to do this for some time, and Daksh has also been at it from a different lens for some time. So I think every idea has its time, and maybe this is the time, and I'm feeling more strongly about it the more I think about it. So Ayushi, if I could request you to please share the deck with that. Um, while the deck comes up, this is a very familiar sight for many practitioners across the country. That note the crowd around this causeless notice board. I'll just take a step back to talk about the Daksh listing project that we started in January 2023. Um, that was an initiative to start thinking about how causeless or how listing of cases actually impact people. Whether your case is listed tomorrow or 2 weeks from later can have a huge consequence depending on the type of your case, on the complexity of the cases. So listing is not as administrative and innocuous as it sounds. It can have grievous consequences on life, liberty, and livelihood. And therefore we started this the listing project, which is, again, we want more people. We don't know how listing happens. We don't know who does the listing. Is it the chief? Is it the chief? Is it the registry? Is it the sitting judge? There are many versions of it. So how does it happen? Who does it? And we also don't know. There is a wide variety uh, of ways in which this listing process output works, and we'll come to that in just a bit. And again, this is a very community driven project. We have senior advocates mentoring us on how to approach this listing project. And as a part of that, when Ayushi asked whether you want to share anything, I thought this is a very good segue for us to all talk about how causeless actually are digital public goods, and how can we ensure that they become one as they currently are not. The next slide, we start from the definition. What is a digital public good, right? People who are familiar with economics will know what public good is, right? It's non-rivalrous, it's non-exclusive, it's not exhaustive in so many senses. It's not for any one person. It's very often used in a negative sense where there are freeloading concerns. In the digital public goods, those concerns are completely gone, right? You have digital tools, systems, devices, even data, which is what is relevant here, which can act as goods, digital public goods that can be leveraged across the ecosystem. A lot of focus on what exactly is DPI, and when I had a call with Saurabh last week, he was saying, is it really digital public goods or is it a DPI? I mean, we can debate that, but essentially, I think we all get the idea of what we are talking about. So then we move on to what are causeless, I think, right? Yeah, I mean, what DPs, this is something that I think PUCAR is working towards, and which is why this conversation is so topical to all of us. What all could be DPGs in the law and justice space, and I don't need to labor the benefits of it. All of us are already sold, which is why we are here. But I think there is a need for us to engage more rigorously on what all could be DPGs. The last time we spoke, Supriya mentioned about the check bounce and other initiatives that are underway. Those are excellent ideas, and we have had many conversations on it. Causeless and judgments and orders could be a subset of those. I'm approaching this merely as something that is more possible, easily possible. And that is why causeless need the least amount of intervention, and therefore should be thought of as the first digital public goods that can be brought out. Um, we're all familiar with what is a cause list, but I would uh, draw your attention to the third aspect, which is it is an important part of open code. So many times a question, why should a third party know about a cause list? I think it is important to understand cause lists are an important element of the open codes principle. The public needs to know, the society needs to know whose case is being heard in which court. um, Also needs to know, right? So, which is the trigger for or a leverage that we have to use to make causeless completely as public as possible. Um, we know that digital consumption of legal and justice data is on the rise. Causeless, as they currently are, do not facilitate that, and Shashwat will bear me out. Um, there are different practices on what how cause lists are currently published. Um, they are not very easy to digest, even by humans, right? We have seen cause lists that are booklets, really. We have cause lists that are completely in jargon, which only lawyers practicing that court can understand. So there are problems with how cause lists are made available to the public currently, which is what we hope to bridge with this exercise. Just to get a sense for people who may not be familiar, this is a sense of a cause list that looks like that is converted from a Word document. Um, so I would draw your attention to Sompal Singh and 9 others versus State of UP and 2 others, right? Who all are they, right? It may be familiar, it may be easy for the person who's got the wakalat or who's tracking that particular case to know. But imagine, what would you look at it if you were a citizen who's just walked into a court complex and saw this? How would that help you at all? Because really, that we have to go back to first principles and look at it from that lens. Just the next few slides are other variations of this. This is the HTML version from the Andhra Pradesh High Court. The next one is also from the Andhra Pradesh High Court, which is a downloadable PDF. So there are formats that have evolved over time. The next one, I think, is where case information is linked. So you can click on this cause list and it will go to the case information, right? So this is fairly more useful than the previous ones. There have been improvements. For example, this is a live cause list. For example, the cases are not heard. All cases are not heard, which are listed in the cause list, are not heard. So, as is there kind of a dynamic cause list? We will have to see how they can be used. The last few examples are where there has been some progress in making cause lists available in Excel format or even in a CSV format. So they are, in that sense, available. We have already continued with this, and I will jump right into the actionable steps, right? The next slide, if you could go through. Right, I think because there are such a erudite audience and people who have grappled with this for over many years, how should we go about it? How should what should an ideal cause list look like? And here we will need to go back to first principles and look at it from a citizen's lens. What do we want an ideal cause list to look like? And then how do we develop a protocol? Of course, there will have to be privacy, because some courts or maybe some types of cases should not be disclosed, or made information should not be available at a large scale. How do we think about those aspects? How do we imagine an ideal cause list to look like? And how do we develop a prototype for getting to that position. I know I'm jumping many steps. For example, the NIC CIS software currently allows for calendaring of cases. And there are courts which use that calendaring option to derive cause lists. But those are not the final cause lists. You derive a cause list, but then there is a manual intervention, the hand of God, and then you get a final version, which is the official version. So if you go by cause lists, there may be exceptions, but if you go by cause lists as generated by the CIS software versus what is actually called out in the court, then there are many times, most often, there are differences. So it is easy for CIS software to generate an electronic cause list, which can then become machine readable and put out for everybody to access by codes, etc. But then there is this manual process that we will have to factor in to making this possible. Those will be the first few questions, and then we can get into what, in your view, would be a strategy to get this embedded into institutional processes to actually make this a reality. And I think I would like to make the most of this session to get thoughts from the people here, and volunteers and people to raise their hand and who want to partner with us in this project. With that, I'll pause, Ayushi, and we can possibly throw it open for comments. And
thank you so much, Surya. As Surya mentioned, any thoughts and comments so far, and any questions for Surya?
Hey, Aishi, this is Shashwat. Hey, Surya. So if I may add, we've been dealing with this issue for a while. We've been working on the cause list, so I can bring in some perspective from litigants or lawyers, especially litigants who have a lot of volume of litigation ongoing. Typically, the service that we've built caters to lawyers and law firms and companies who have typically who handle a lot of litigation. And we understand their perspective of what is missing and what can really help their lives. So I'd like to share a little bit about that. So one thing that really hinders people's access to information. If we can actually bucket it down, right? One problem that we see is difference in formats, right? So today, for instance, we track data from across e-courts, high courts, practically all forums that are online. So this is cumulatively, if we capture, this is close to 10,000 courts, 9,000 odd courts. And in our experience, we've built about 80 to 90 different types of scripts that run to sort of capture this data, right? And those scripts are also very brittle, because one code would suddenly change a particular format in which they release information. There are so one is formats, right? I mean, that across all codes there is such a stark difference in terms of formats in which information. Some courts will give out information for all petitioners, respondents. Some will put in others and all. So that is a major challenge. Missing information, right? Some courts publish more data, some courts publish less data. Correct. Some will push in the FIR. So we're right now talking to multiple state departments. And the sad part is that people who are sitting inside those court complexes are not able to influence these decisions. So we are working with some AG offices in different states, and the AG office, which is practically inside the High Court complex itself, is not able to decipher this, right? The state is not prepared to appear for the matters that they are part of, right? So they need more information in the causes. They need information for criminal matters. They need FIR information, other information which could be. So one category of problems is incomplete information. What more could be there in the cause list? Also, one other major challenge that we see is so there are main lists, there are supplementary lists, there are monthly lists, there are weekly lists, and so unless you practice in a particular code, it is very difficult for. So when we integrate a new code onto our platform, it is a learning experience, right? It takes us months, weeks to also understand the pattern in which this data is published. What are we missing? So continuous user feedback. And so as somebody who's trying to get access to the data, you could be a researcher, you could be a bank who has a lot of litigation.
Yeah.
You want to build direct access to these websites to just know what matters you're a party to, right? It is just a very, very difficult exercise. And today, with all the effort and engineering that we have put in, I would say that we are only able to do this 90-95% of the time. We miss out 5-7% of the updates because it's a moving goalpost, right? Obviously, they make it hard to access information with captchas, and I'm not going into that area, but just synchronization in terms of formats, machine readability of formats. Today, we end up using a lot of OCR. Nothing is perfect there, right? So that is one, and maybe some more information, right? We have our customers coming back to us talking about the kind of information they would want to see in the cause list. So yeah, I would categorize these are some of the issues that we face regularly. And yeah, that was sort of my feedback on.
So 3 points I've noted down, Shashwat, and please feel to add. What more could be in the cause list? Varieties in the cause list, and how do we influence the policymakers to make the switch? These are the 3 main things that, yeah.
Yeah.
Can I? Yeah.
Sorry, Surya, please say what.
No, I was just saying whether you will call out or yeah, Pavitra, yes.
Oh, please go ahead, Surya. Please call out.
Okay, hi. Yeah, so just picking off from the last question, right? Like, how do we influence the policymaker? So I think we have 2 major questions. How do we position it so that the policymakers think that this is an important change that needs to be done? And secondly, Surya, to the first, when you started the presentation, you said, how are cost lists even made? How do they come up with the cost list? Nobody knows that. To some extent, I think these both can be related. So, which do we work on first, right? Do we work on getting a formal, proper digital cost list generated by codes, or should we change the process of how the cost lists are generated in the first place, which is a predecessor and which is a successor?
Yeah.
So one thing that came to my mind is, okay, we are saying the public need to know versus others are there, the public needs to know, right? But why does the public need to know? I have my case number if it's my own case. Apart from that, anybody walking on in the court complex does not want to know whose case is going on. So probably if we strengthen the system of how the cost list is generated in the first place, and which is taking inputs from the court orders that the court is giving, then maybe there is a scope of it automatically getting generated in a more digital format, which is easily accessible, scrapable, or I don't know what is the exact term to use, but not a PDF picture, etc. So that's just one thought that I had.
Great point. Yeah, it's a great point. Before I ask Siddharth and then Mayank to respond or add on, I think there is a case to disaggregate the problem. Whether if you want to make administrative process change and information dissemination change, maybe we will be taking on too much. Because there are political economy issues when it comes to how cause lists are prepared. I mean, that's a nice word. We know what it means. But if you just focus on a top-down data transparency, maybe it will lead to a bit more. The sunshine will kill these, the bugs in the process. That is an approach that is worth considering, and possibly we should take that. Put more data, make more data available. which may help in cleaning up your internal backend processes.
Right. And in a way, it's the lowest hanging fruit also,
Correct.
the first question.
Correct.
Yeah.
Correct. That's a great question. Yes, Siddharth.
I just had some thoughts. I agree that you need to split the IT and the process re-engineering in this case, because I think there is an ongoing system of preparing cause lists, and the least they can do is give people access to it in some form of machine readable digital format. I see it as a few questions as to what information must be there, which I think you've already discussed. The second is perhaps it could be interesting to discuss what kind of tech architecture or what kind of mechanism, which is we get market data on a regular basis. So there's like content pub sub model, and there are other ideas. And then as and when the cause list updates, ideally everybody gets an alert, right? And the courts or the DPG should just be just them putting out this data out into the open, on which top of that, people can use this data, see, okay, has your case come up? Should I send you an alert? People could build all kinds of interesting applications. The who, I think, in terms of the locus of operation, even if you get one court to agree to this as a pilot, right? And it needn't be done in some extremely complex, everybody needs to be aligned to this process. Even if you can find one friendly judge, and all you do is take the cause list that's already there, have a data entry operator, convert it into a digital format, show them that this can work. I think that itself might be interesting enough as a proof of concept. So you just you implement the DPG in with one court in one area, and keep the physical process, of course, ongoing, the existing process. I think the hardest question for me to understand is why, which is why should somebody agree to this apart from the fact that we all think it's useful, it's necessary. As a research community, it's great to have access to this kind of stuff and even measure how often do cost lists get changed, and what happens. But I think that is how do we actually convince people that this is useful? Because the argument will be, yeah, whoever has a case in court, they can always look it up. Don't you think this allows people to know how many cases are against somebody I don't
else.
like? Yeah, so this is probably a challenging question that, despite our focus on transparency, might be worth trying to think of what is a good answer to this.
Yeah, so that completely agree with you. I think Shashwat can help us kind of maybe lay out why it's not just researchers. In fact, it is the litigants on a day-to-day basis who need to know more. They will have case in Baroda, Bombay, right, Coimbatore. So maybe we can lean on him. The prototype, I think you kind of, I will probably extend your argument. We need to develop a prototype or a protocol and prototype for converting current cause lists into a DPG. That would be a great end result for this conversation to be. Mayank and then Deepika.
Hi. Yeah. So just taking up from where Siddharth left off as to why it should be a public good, right? Now I have two separate points. The first being that, there are certain cases where the courts state that the names of the litigants should not be there. And Siddharth will be aware. Right. For example, in Delhi family courts, the names of the litigants are not there.
Some courts,
right?
yeah.
Some courts are very clear about that. So it is not always that it's a digital public good. Sometimes the privacy of the individual matters far more.
Yeah.
Right? So we must keep that in mind when we are moving forward. The second thing being that why is it that what is the purpose of a cause list? Right? Let's get down to roots. The purpose of a cause list is to let someone know when and if will their matter come up. Right? Even if you don't go into the general public. Now, if you see, even that is a problem, because across courts in the country, starting from the Supreme Court to the District Court at Byawar, right? On certain dates, A, the matter will not come up. B, the cause lists are made in a fashion. For example, in the Delhi High Court, usually when I am there, at least 3 people will come up and ask me, ki, hamara matter kab aa raha hai? When's the matter coming up? Because some judges have the supplementary list first, then they will go into their advanced lists. In the middle, one judge turned it around and said that, no, I will take all advanced list matters first, and then at 2:30, I will take up supplementary lists, right? So the issue of timing and when and if your matter will come up gains significance, because it is a it is genuinely a waste of time.
Yeah.
Right. And if you're, yes, because man hours are wasted essentially with people waiting around, doing absolutely nothing, and your matter may not even come up.
Yeah.
And one of the major places where this happens is in the Supreme Court of India, right? Where you have computer generated lists wherein the matter maybe just keep getting pushed date after date, and then you're given 1 week's notice or something like that. So if you're actually working on a cause list and you are trying to work on an ontology, it would also be efficient while you are trying to scrape the data to make it in a manner where the litigant actually knows whether his matter will come up or not. It is I know it's a stretch, it's a challenge, but that's a real problem that people face on a day-to-day basis. So if you're looking at a company, if you're looking at whoever you're looking at, right, who's doing this, whether your matter will come up or not is the number one question which people have, and I am sure that can be managed. For example, in Delhi, any lawyer will be able to tell you that this judge will get up at this point of time. And by the way, that is something which you can use AI, you can use whatever to see that these are the usual methods by which they sit. In Delhi High Court, a regular list. So there are 3 lists which come out. One is a supplementary list, one is an advanced list, and one is a regular list. So regular lists are matters which are listed every day. Right. But they're never taken up. Correct. They're the most irregular of all matters. So keeping that in view, you can, for example, I use Siddharth's product. It's a very nice product. As a lawyer, I can say that.
Shashwat, you mean?
Sorry, Shashwat. Yeah, sorry, Shashwat's product, ProVakil. Yeah. So, and it's a very nice product. And but the factor is that, if a regular matter is coming up, I get to know every day when I know that it's not going to be taken up. Yeah. Because of these reasons. So when you're dealing with this is also something that you may want to keep in mind.
No, absolutely right. I think just a little insight. When we started the listing project at Daksh, January 23 or maybe December, we were wondering what to call this initiative because it's coming together. Essentially, this is a case flow management problem, right? Figuring out what to do first, whether you are scheduling enough cases or enough or less. But if you call it the case flow management project, it doesn't sound attractive enough. So we called it the listing project to attract more people, but we are completely conscious that it is in essence a case management problem, which is exactly what you talked about, Mayank. And once the data is available, a lot of the tools can be built to inform and maybe show a mirror to the people that it is not working, the scheduling is not working. Absolutely right. Yeah, Deepika, then Saurabh.
Some of the points that I wanted to make have been covered in bits and pieces by the previous speakers. But to encapsulate the various discussion points, I think we will have to approach this problem statement in a threefold manner. First level is definitely to answer the question why. And why from the perspective of all the stakeholders, the most important one being the system itself, right? The courts still see cause lists as a transactional document. It is something that is between the parties, advocates, and the court. I don't think the lens has come in yet to see this as a public good, the way we are currently discussing. Now, even if we are able to convince the system that this is how they need to be seeing it, the cost or the cost in terms of time and money that they will need to invest to make those changes need to be justified with the returns that they get as a system. So therefore, when we look at making that case for change, can we look at what the court can derive out of a more systematized and more comprehensive cause list? And to do this, I think we will have to go to the second and third layer of questions, which is what and how. What is it that they need to do in the current scheme of things to arrive at that more comprehensive cause list? And for this, we, I think, as a community, driven by Dakshas Project and several other initiatives that are already on ground, identify those specific metrics that we are talking about. There is nothing better than show and tell, and we as a community, we have come to realize that. So can we create a comprehensive cause list which will speak to the requirements, not just today's requirements, but potential future uses from all stakeholders' perspective? Show them that if they create these data points, start collating data against these metrics, over time, this is how they will benefit. I think that is the only way of pushing them to make any change, because right now, from their perspective and even from most of the advocates' perspective, things are fine. It is us as a community who are finding fault with it because it's not giving us the data points that we know we will benefit from. So that is one point that I think we should start from, making a stronger case for change.
Yeah. So on the two responses, brief responses. One is on the why. I think we are just giving voice to many people who are not come together and voiced it out. And legal tech people and practitioners could vouch for that. They also have issues. So this is a way to give vent to their expectations. And the cost, I think we should not be over optimistic that you will get an ideal cause list. We should sit down and imagine it, but it will get there. But we should try and make as incremental a change as possible so that the direction is set. The intention is translated into action. And so you're putting it up on the website. Click this button here. We are giving you a plugin. Click this button here, which will make this a CSV file in this format, which also you can post on your website. Can we reach that level, small change to their workflow so that they don't feel that they have been disrupted, their life has been disrupted? I would possibly approach it that way. The big change we should work towards over time. So, thank you, Deepika. Saurabh?
Yeah, I mean, because I don't understand law too well, so I don't have question on the cause list. I wanted to basically ask, like, right now there are three areas of work that Daksh has. One is which, like, at least like I know of, like one is like ontology, second is the wiki project, and the third one is cause list, right? Just wanted to basically ask you, like, what is the grand plan, right? Like, how do these different ideas connect together? And I mean, like, feel free to, but what I want to understand is from information standpoint, like, how do these ideas connect and how the world would change if there is any imagination around that?
A good question. I don't know whether I have thought through that. The ontology may be related because there are terms used particularly in cause lists. So you could say that there could be a shared conceptual terms and knowledge graph that can be built only for cause list data. The wiki is more not a technical definition. It is more a socio-legal and institutional lens to terms, which we launched just recently. There it gives you a timeline of how the idea has evolved and the geographical variety to it. So the wiki is a way to ultimately lead to ontologies which are technical and maybe even machine dependent, but leading into a solution, which is what we are working towards, a prototype and a protocol that can hit the ground based on this trajectory, which justifies each other back. That's how I'm thinking about it. I don't know whether that answered your question, Saurabh.
No, I mean it did, and interestingly, you mentioned like knowledge graphs, right? Like, so I think one is the stated problems that a system would have. That's how at least like my naive mind has been thinking about it. Is like one system would have like a stated preference that these are some of the problems that I will solve. If notification is that one, I think some form of like data will probably solve for it, right? And the question I think like everyone else is also asking, like, what changes when you make this data available? Like, what can you do today that you can't, right? And my sense is like it'll be some or the other application of like knowledge graph. So one thing is like, how do you sort of promote research in that area? From an AI/ML lens, like at least I see that there is a lot of work that can happen once you have these entities sort of like.
Correct. I missed that. Yeah. Correct. Good point. Yeah. I missed that point. Siddharth and Pavitra also have raised their hands. Priyamvada has also raised her hand. I mean, you guys can choose. Maybe Siddharth, you want to go? Yeah.
Okay, I just had an idea while everybody was talking. So one, we understand that there is a forward-looking cause list, and then we know at the end of the day what actually transpires in court may or may not be the cause list. Now, instead of framing it as a scheduling problem or that require the courts to do more complex things than what they're already doing,
Correct.
we should think of this as a very similar to how the stock market data works. Okay, so basically you have a position. Once there is an update on your position, then you get only that information. So ideally everybody should be able to subscribe, and it could be paid, it could be free, there could be, if you're doing a bulk thing, there could be ways to help the court monetize some of this over and above single queries, right? So that if there is a cost angle, you could say that, look, if you're a bulk service provider, if you're going to bulk query us beyond a certain number of API calls, we're going to charge you for it. And the idea would be that at the start of the day or any time before the actual court is due, you can query the cause list. You will get a set of data. At the end of the day, the court simply needs to update which of these matters got heard and at what time or in what order, right? It could be just a numbering or it could be the time itself. And this doesn't require them to do more work. This doesn't require them. I mean, obviously they need to tag it, and ideally we should help them have one point of data entry, and that point of data entry diverges into whatever they're using for their website, whatever they're using in printing out if there are physical cause lists put up, and whatever is being provided as API access. But the idea is that you should have a mechanism of not just pinging the data once, but as and when there is an update, you should ideally be also allowed to listen to updates and subscribe to updates, very much like
Correct.
how you do with market data streams.
But once the data is available, the tools built on top of it can enable that. I don't think we should ask the courts to do that updation. It should, I mean, the
So I don't
original
know how-
record updation will have to happen through the court, but the notification to you will have to be through the tools that you subscribe
So
to.
it depends on our DPG, how we architect it. So one is, of course, we could say that the court only has to put out a flat thing, right? Which is every day you need to update. And the DPG will listen to who's been listening to this data point. So obviously you could now make the people who sit on top of this data keep querying the data at regular intervals and then build an alert system. Or like people do with market data. Again, right? It depends. Do you want the court to make money? In which case it would be a nice feature for them to also have this as part of their, how many subscriptions are you doing it and stuff like that, which might incentivize them to say, okay, fine, if we're able to cut costs, I mean, whatever, break even, we may decide to offer some services like this.
Right. Good idea. Yeah. Worth exploring. Pavitra and then Priyamvada.
Yeah, I have an open question. Sorry, I don't have any solutions. I thought one more interesting question that we need to understand is why are they not doing this? It's not like they don't have the information, right? For instance, NCLT cost list used to be beautiful. They used to give us information on what happened at the end of the day, etc. And sometime over in the middle of last year, they just stopped it. So because we have this community that we can tap onto. Agami has its own contact. So it would be, maybe it's important to have these conversations with people on the inside to understand what is incentivizing them or disincentivizing them from putting this. Is it just the cost that is, because it doesn't really seem like just a cost problem.
Yeah, but fair enough. It's worth exploring, and it raises a thing that I wanted to kind of round up the discussion, because I think we're nearing end, and maybe we should think about next. Thanks, Pavitra. Good question. Priyamvada and then Smita from Daksh.
Yeah, hi. I just wanted to very quickly say something that I think we haven't really been discussing yet. Might be a bit of a tangent, so sorry about that. We have been discussing cost lists purely in terms of the kind of information that they give to litigants and to lawyers. But I think another goal of the purpose being served with the cost list that we do need to take into consideration is the fact that a cost list also tells the judge how to organize their day. It tells them how their judicial time is going to be spent and hearing what kind of matters at what stage during the day as well. So I just think that is a perspective that we need to take into question, because that will raise different complexities rather than just in terms of coding to be able to get a digital cause list out. You would also need to take the different factors and different nature of cases being heard into account and so on and so forth. So just wanted to bring that up.
Correct. So we kind of assume that the judge knows how the cause lists are being done. You're right, it's not always in his control. The registry just comes up sometimes. Great point. Yeah, Smita.
Hi, I just wanted to thank you so much, Pavitra, for bringing up the point about NCLG. Bhargavi and Pavitra had mentioned this to us, I think, last year when we were working on the listing project and thinking about what kind of information is available even for courts in general after the hearing is over. So I think, as people have mentioned today, it's been interesting to us that the system at large has the update whether the case has been reached or not, whether the hearing has been reached or not, has the update if it's been adjourned to when it's been adjourned, has the update what's kind of the next step. I mean, what's the next the next step, like the next purpose of hearing or whatever might happen next in the case. This is available separately within kind of the overall database that a court would manage. So is it something that would be relevant or interesting would be useful for transactional users to have that like updated into a cause list, or even added as part of, say, a more granular way of understanding the current purpose? Is that something that might be useful in thinking about this ontology, useful in thinking about how a cause list could and should look? I just wanted to add that.
Right. So the next purpose of hearing, the next stage of hearing, whether that is also an important component that can be added into this cause list project.
Yeah, so just to kind of, because I'm sure many people in this call will already be familiar, but for anyone who isn't, I think we realized that when you kind of go into e-courts after a hearing with the case number, you kind of have, once you dig one level down, you get like a generic sense of whether an order has come, what has happened that day, has it been reached or not. And if you click on the right place and hyperlink further, then you get a slightly kind of crisper sense of what's actually going to happen next. So these things that are disaggregated or distributed across the database, kind of put together in one way.
Correct. So, Ayushi, I think all the questions are done, and if there is no other questions, I wanted to request volunteers and participation on. I think there are 3 elements of the next steps, right? One would be talking to courts, judges, registry staff, lawyers, figuring out how cause lists are actually generated, which is one part of it. The other, I think, would be a concept note or a paper on why the positioning of it, the rationale for how it will help many kinds of people, and why cause lists should be seen to be DPG. So a concept note. And the third would be developing a prototype and a protocol for helping courts quickly transition to cause lists as DPGs. So 3 different deliverables that I think which are critical to this project as we go along, and all those who are interested, how do we take this forward? They'll reach out to you, and then we can take this forward.
We could send out an email right after the call detailing these 3 roles, and and maybe they could reach out. People who are interested could reach out to you.
The Daksh team,
yeah.
But are these the 3 elements that others also agree with? And is there anything else? Supriya has a comment. I'm just looking at it. Yeah, would help if we can articulate the why, which aligns with the high priority for judicial leadership. Correct. So which is what the note should do, and I think the more people can help develop that note, and the Ajay Shah model, as big sign up as possible. The co-author list should be more than the paper. Then it will really show why it's all of it is thanks Supriya for offering help. But I would really appreciate if people could come forward and volunteer to be a part of it. I know Shashwat I think development of the protocol and the prototype would be really, really critical in this journey. And I hope you can spare some time for that. I know your interests are aligned. If you could also spare some time and energy for this project, it would be really helpful to take this forward. Yeah, great. Thank you, Aishi. I don't have anything more. Thank you for the opportunity.
Thank you. And this is super exciting. And hopefully there are more people who want to work on this, and we could maybe take it forward asynchronously. One question that I've been holding is, how do you take the litigant's lens when you are working on problems like this? I don't have more to offer in terms of how do you go about it in terms of the specific project, but just holding that lens when you are designing anything of what that means for the litigant and what would the litigant want this could look like. Okay. Thank you so much, everyone, for joining us for the second learning circle. And I'll share the recordings with everyone. And if there are any questions, we could take it offline on the WhatsApp group or on email. And see you in the next learning circle. Thank you so much.
Thank you so much, everybody.
Bye. Bye.
Thank you.
Bye.
Bye.
Thank you.
I'm feeling like I should stay back a bit more, not leave immediately. Thank you so much, Aishi. Really helpful.